Madam Clerk, item 12.
Conduct a notice published hearing to consider adopting an extension of an interim ordinance imposing an additional 22-month and 15-day moratorium on medical marijuana dispensaries in unincorporated Solano County. Is there a motion to read the ordinance by title only?
Please vote on.
There's a card.
One moment.
It was just to read by title only.
Not the entire ordinance.
So ordered by unanimous vote.
Okay. With that, presentation.
Good morning. I'm Karen.
I'm sorry, I do open the public hearing. Okay. Open the public hearing.
Hi, I'm Karen Avery with the Department of Resource Management. Today, we're asking for an extension of the moratorium for 22 months and 15 days. On September 22nd, we requested a 45-day moratorium. In those 45 days, we've been gathering information about from other cities and counties and jurisdictions about medical marijuana dispensaries, how they handle it, some of the concerns that they have. So we're continuing to do that information gathering. So we're asking for an extension so that we can continue to put this information together. There are also some outstanding legal issues and some cases that are quite important that we're waiting to hear from as well. So with that, we're asking for an additional 22 months and 15 days.
I do have several speaker cards. Board, any comments first? Barbara? Yes.
Why do you need 22 months? I mean, these dispensaries are up and running all over the state. There have been numerous articles on, for instance, how Oakland's is running very smoothly with all of the inspections and the safeguards in place, and then others are not running as well. So it seems to me that I just don't understand. 22 months is almost 2 years. That's
right. That's the maximum allotted. We do think we will be back to through the Planning Commission and to the board within those 22 months.
right, but within the 22 months,
Mm-hmm.
there are a lot of people. I mean, this now is the medicine, and there are a lot of people who need that medicine who have a prescription for it and will not be able to get it if everything rings true with all of the cities putting moratoriums on, and there's some question about the legalization of that. So there's no question about the legalization of opening one. It's a question of, is any community allowed to just ban it? So I'm just thinking 22 months is outrageous.
I guess there's a couple questions here. First, on the 22 and a half months, that's the time limit given by the statute, and it's essentially an amount of time that the county can put a pause on everything, call a timeout, and it gives us time to come up with an ordinance. You don't need to take that entire time. Once we develop our ordinance, decide how we're going to regulate these things, we'll be back on the board, and whatever the board decides to adopt at that time will supersede the moratorium, and the moratorium at that point will go away. So the state law says the procedure we're following, the state law is you first get 45 days, and if the 45 days isn't enough, then you get 22 and a half months on top of that. So there isn't too much flexibility within the state law. You definitely cannot go past 22 and a half months at this point. The staff intends to come back much sooner than that whenever they can get through this process. As far as can a moratorium, can we impose a moratorium, or is that somehow in conflict with state law? There was a Court of Appeal decision from earlier this year, it was published about a month and a half ago, where the Court of Appeal said it was okay to use the moratorium powers under the Planning and Zoning Act to put a temporary moratorium on medical marijuana dispensaries. And there was no state law preemption that prevents you from doing that. But again, you do have to make up your mind, decide what you're going to do within the remaining time now, this 22 and a half months.
There's a sentence in the staff report that says, based on these sample ordinances, some of the issues that must be addressed if the county chooses to permit medical marijuana facilities include limiting the number of clinics, the concentration of the clinics, security of the clinics, and the clinic's proximity to schools, churches, and other sensitive receptors. And I can understand the security issue and the security issues to make sure that only those who are entitled to or who have prescriptions have access to the marijuana. But the proximity to schools, churches, and other, that's like saying that a pharmacy it shouldn't be located near a school. This is not like Amsterdam where people are going to be sitting out on the sidewalk smoking joints. It's crazy.
Yeah, communities are wrestling with how to regulate these things, what are legitimate concerns or what doesn't need to be a concern during the process, and some communities are looking at these like adult bookstores and using that model to regulate these types of activities. And or alcoholic beverages where you do want to create separation from other sensitive land uses.
Where these are permitted and up and operating already, the free market kind of takes over. There are those that provide good service, and the ones that don't go away. I just think that in a county where a majority of the voters approved this medical marijuana, from personal experience of knowing lots of people who have used marijuana to alleviate symptoms, especially those people with cancer, this is just, I can understand putting it off for a brief while, but certainly not for 2.5 years.
Actually, can I ask a quick
Yes,
question? If this doesn't receive a 4/5 vote, what happens? So there's no moratorium, so
it
someone can
requires
open up a
4/5.
dispensary tomorrow?
Right now, you do have a moratorium in effect. It's good for 45 days from adoption. I think the 45th day is this coming Friday when that runs. And at that point, if you decide not to extend the moratorium, that'll go away at the end of the week, and then we're back where we were essentially 2 months ago with.
But what does that really mean?
Could
someone open up?
It's unclear what our current state of regulation is at this time. We don't have any explicit provision for medical marijuana dispensaries in our zoning ordinance. We do allow pharmacies within the CO zoning district, which is essentially Cordelia, and saying pharmacies are the closest analog to a medical marijuana dispensary. Well, it's possible someone could apply for a business license within that zoning district. It's just that our current zoning doesn't say exactly how to regulate these things. So we were hoping to come up with some new rules and come up with some clear guidelines on where and where these are not allowed. So, if we go back to status quo, then it's.
And Bridgetta had a comment too, I think.
How are the cities doing this with the simple majority? The cities are passing these interim ordinances. They're doing it with the simple majority. Why is that? Why can't the county do that? I don't understand the 4/5.
That comes out of state law. We were just following what the state law requires.
Says that any ordinance or any
moratoriums.
An urgency moratorium requires a supermajority of the board.
Assume it doesn't pass today. Then we want to bring it back and just do it a month from now. What prevents us from doing it?
Adopting it as a moratorium requires the 4/5 vote. If you come up with some regulatory
Any moratorium that we
that's correct.
Requires the 4/5 vote.
Your permanent ordinance will just be a simple majority, whatever you decide to do as far as regulating these things. But as far as imposing a temporary moratorium, that requires 4/5 vote.
Which is essentially a timeout.
A timeout, basically.
Can it be less than 2 years and 15 days?
Yes, and that's what I was going to say. You could specify a shorter period of time, and if we're not ready, then you'd have to grant an extension. The maximum is the 22 months. The issues before us are not only the zoning and where does it go. If you think about your unincorporated county, Benicia, Cordelia, Elmira, Rockville, you don't have very many unincorporated